Morning, everybody.
Morning.
Hey, Susan,
Good.
Morning.
we're gonna go to afternoon in just like 1 minute.
Yeah, indeed. How you doing with all the paper, Lloyd?
It's I'm finding places to put it. I have a closet that's now been taken over.
You're
It
gonna need
happens
it.
quickly.
Uh
It happens quickly.
yeah. It's but I got a shredder.
All right.
So May, I see that we're on YouTube, and just let us know when you have the recording ready.
Correct. We are live and recording.
Very good. Off to you, Tracy.
Thank you, thank you. Good afternoon, everyone. My name is Tracy Metzger, and I'm Chair of the Albany Industrial Development Agency. Today, we are holding this public hearing pursuant to sections 201 through 203 of the New York Eminent Domain Procedure Law with respect to the acquisition of certain parcels of real property. I will now ask Chuck Malcolm to make a presentation regarding the purpose, proposed location of the public project, and other relevant information pursuant to section 203 of the Eminent Domain Procedure Law, after which we will hear from the applicant, Capitalize Albany Corporation, and then we will open the public hearing. Chuck?
Thank you, Chair Metzger. Good afternoon. My name is Chuck Malcolm. I'm an attorney with Hodgson Russ, counsel for the agency. Due to the COVID-19 pandemic, the public hearing today is being conducted via the Zoom video and teleconference platform in accordance with executive orders issued by Governor Cuomo. Notice of this public hearing was duly served on the assessment record billing owner and its counsel and was published in accordance with section 202 of the Eminent Domain Procedure Law. In accordance with section 203 of the Eminent Domain Procedure Law, a stenographic record is being made of this hearing. Written comments submitted will be included in the hearing record. This material will be available on the agency's website, www.albanyida.com, and as required by law. The agency has been accepting written comments at info@albanyida.com. We have received several written comments and letters, and they will be included in the public hearing record. The proposed project includes the acquisition of 11 tax parcels consisting of approximately 0.88 acres of underutilized stagnant surface parking lots in the heart of downtown Albany and at the center of one of the capital region's most important potential redevelopment sites, Liberty Park, for the purpose of facilitating Capitalize Albany Corporation, or CAC's, revitalization and reuse efforts for economic development purposes. The 11 tax parcels that make up the subject property proposed to be acquired are as follows: 76.50-1-11, 24 through 28, 29 through 30, 32, 33, and 35. The Liberty Park District redevelopment project location is bounded by Broadway to the east, Hudson Avenue to the north, Hamilton Street to the south, and Green Street to the west. This site is approximately 8 acres, and CAC has control of the site with the exception of the parcels proposed to be acquired by the agency by eminent domain. These parcels' central location within the site makes them essential for redevelopment purposes. A map of the Liberty Park redevelopment site is available on the agency's website at www.albanyida.com. And at this time, I would like to ask that we share the screen and put the map up so that everybody on the line can see it. If you're connecting by telephone, again, this is available at www.albanyida.com as public hearing materials under the meetings tab on the website. And May, if you could scroll up to page 1. There are 2 maps, both showing the entire Liberty Park redevelopment site, with the parcels to be acquired highlighted in red. And if you'll move down to the second map, May. Another shows the parcels proposed to be acquired indicated with markers. The maps provide descriptions of the property to be acquired and adjacent parcels. The parcels proposed to be acquired are the remaining property required to complete the assemblage necessary to move forward with a future redevelopment of the Liberty Park District, which could yield over $100 million in new investment. The proposed parcels to be acquired have been identified in the Capital Region Economic Development Council's Capital 2020 Regional Economic Development Strategy and outlined in the 2017 Empire State Development Downtown Albany Planning and Feasibility Study, as summarized in the concept plan report prepared by CHA. Acquisition of the parcels would allow CAC to move forward with the planning and public review and input process for redevelopment. The purpose of the acquisition is to promote economic development to remedy blighted conditions, underdevelopment, and underutilization. An existing conditions assessment was conducted for the site, finding that the site consists mainly of surface parking lots in significant disrepair with poor pavement conditions, stagnant uses, and long vacant buildings which have been flagged as unsafe for emergency responders to enter. The site as a whole generally suffers from economic underdevelopment. Now, unless there's any objection, I'm going to suggest waiving the full reading of the notice of this public hearing and instead request that the full text of the notice be inserted into the record. Hearing no objection, I will also note that general information on the agency's general authority and public purpose are contained in a separate statement and will be entered into the public hearing record. As the chair indicated before we start the public hearing, I would first like to introduce CAC and ask its representative, Tom Conoscenti, to make a brief presentation with respect to the proposed project. Tom?
Good afternoon and thank you. My name is Tom Conoscenti and I am Vice President of Capitalize Albany Corporation. Capitalize Albany is a 501c3 not-for-profit corporation and local public authority. Its mission is to facilitate transformational development projects serving as the City of Albany's economic development arm. Capitalize Albany, which is the subject application, which is the subject of this public hearing, is for property acquisition assistance through the use of eminent domain by the City of Albany IDA to acquire 11 parcels totaling 0.88 acres in the Liberty Park District from PSC LLC in order to develop and pursue its concept economic development program. No financial assistance is being requested from the IDA. For several years, Capitalize Albany has endeavored to acquire lands in the Liberty Park District, an area for which decades has been home to underutilized parking lots that represent economic underdevelopment and stagnation in the heart of downtown Albany. To date, the corporation has successfully acquired the majority of the site, totaling 7 acres, through voluntary negotiated acquisitions. During the same time period, Capitalize Albany has sought to pay fair market value for the remaining 0.88 acres in question via negotiated transaction to no avail. This final acre is the last remaining property needed to complete an assemblage necessary to move forward with the redevelopment of the Liberty Park District, which has been cited as a key redevelopment priority in multiple local and regional plans. Based on the concept plan report that Capitalize Albany submitted with its application, a redevelopment of Liberty Park could yield over $100 million in new investment to the area. Thank you for your time.
Thank you, Tom. The agency will now open this public hearing at 12:10 p.m. By way of operating rules, members of the public who pre-registered on the website will be called in order of their registration. If you did not pre-register but would like to make a statement at the public hearing, please hit *9 on your telephone if you have joined via phone, or select the raise your hand function on the Zoom platform. Once you've been added to our list of speakers, you will be notified by Zoom that your hand has been put down after you speak. We will add speakers in the order in which they are registered. If you did not pre-register, we will call on you to speak by reading the last 4 digits of your phone number if you've joined by phone. We ask that everybody mute your phone and turn off your video camera unless you have been called on to speak. Once you have been recognized, please state your name, address, and affiliation for the record prior to making your public comment. Speakers may also provide written statements to info@albanyida.com. The purpose of this public hearing is not to field questions, but to solicit public comment and information on the proposed project from the public. And so now I'm going to go and call on those who've pre-registered. We've had one person pre-registered to speak. That's William Canary. Mr. Canary, if you're there, could you unmute your line and you can begin.
Thank you, Mr. Malcolm. Good afternoon, members of the IDA, Chairwoman Metzger. Most respectfully, I'm here today on behalf of Mr. Paul Chambers. Mr. Chambers died on October 26, 2003. Before he died, he operated a small and successful business in downtown Albany, using the property that Mr. Malcolm has just been describing. That property is the subject of the proceeding before you. The property has been owned by the family members for many years and for several generations. For many years, the property has been rented for public parking. Like many small businesses, the real property has been the source of income for this family, the Chambers family, for many years. And today, it is the source of income for Mr. Chambers' wife, who survives him. Mrs. Chambers is 83 years old. She has a daughter and a son, and they have spouses. They all live locally. Her children are responsible people, they're employed, and they're private. She has several grandchildren. Mrs. Chambers relies on the rent from this property. She uses the rent to pay her bills. Understandably, Mrs. Chambers and the family do not desire to have their property and their business condemned and taken from them. The family's expectation has remained that their father's hard work for their mother would allow her to live the remainder of her life without a lot of worry. They certainly never expected the lease to be terminated out from under her. Today, in contrast with the introduction that we've heard concerning this purported project, the fact is the property is simply not abandoned and it's not blighted. It's actively used. The real property that's being subject to condemnation and considered for acquisition has been and significantly remains in use today for a public purpose. That public purpose, of course, is downtown City of Albany parking. Public parking is obviously a public use. The condemnor IDA's new unspecified purpose has been labeled Liberty Park Mixed Use Development. Whatever that is, I believe we can all agree, will interfere with the present use as downtown parking. To be sure, it will not merely interfere with the use of the property for a public purpose as it is today, but it will destroy it forever. And this small family business will be killed. This is significant because at the end of the hearing in the finding statement, we submit that you, acting as responsible members of the IDA, must find that the real property is now currently being used for a public purpose in factual contrast with what was just represented. The written lease contract for the property that's in effect today states that the property is to be used for parking. The lease is dated August 15, 1988, with a term of 50 years. Thus, as we're together today, there are 18 more years that Mrs. Chambers is relying on in that contractual term. The lease says that at the end of the term, the real property stays with the family. The condemnor has no right to breach that contract, and the condemnor has no right to simply change its mind on a whim relative to the lease contract, which was fully negotiated and made in 1988. Mrs. Chambers and her family are most respectfully asking you to find this effort simply offensive. This is arbitrary. This is unfair. And the taking that we're talking about today is a gross and excessive and unlawful exercise of governmental power. By way of background, in arriving at where the family is today, the lease has been the subject of a governmental shuffle or a shell game. The family's experience has been very much like having a mortgage, as probably many of you do on your residences. And you find you have your mortgage with one bank, only to find later on after your closing that you're doing business with a fifth or a sixth or some other bank down the line, and you've had no contact or communication with them whatsoever. You've never even heard of that bank. Unfortunately, that's the case here with Mrs. Chambers and her family. And now, today, they're here before you most respectfully on the ugly end of this. Several years ago, the Albany County Convention Center Authority planned a convention center on this very property. And what it did was it managed to get the lease that we're talking about assigned to it. It paid the rent, and unlike the Chambers family, it also managed to get the property exempt for itself from paying real property tax to the city of Albany. As you know, the convention center came to be built elsewhere, but the Convention Center Authority remained the tenant on the lease that we're discussing today. More recently, in 2017, a corporation called Capitalize Albany Corp. managed to get the Convention Center Authority to agree to sell and assign the lease to it so that it could take control of the property under the lease for the purpose stated under the lease. That is public parking. Capitalize Albany Corp. Failed. And that at the end, that agreement between those parties also failed. After that, the Convention Authority sought to assign the lease again, this time to yet another company, Liberty Square Development LLC, a limited liability company, which on its face we submit sounds very impressive, a development company. But unfortunately, Liberty Square Development LLC is Capitalize Albany's own limited liability company. It wholly owns and wholly controls it. It has principal offices at 21 Lodge Street, where Capitalize Albany's principal office is located. Same address, wholly owned. This convoluted assignment of lease was accomplished by scheme or shuffle with Mrs. Chambers. Incredibly, and you may react to that, but sit back and think if it happened to you. Incredibly, this is remarkable. When Mrs. Chambers asked and began to ask legitimate questions about what was going on, the response she received was, "We may terminate that lease. Fall in line." We believe and we submit that the members of the IDA are above that, and you too will find that to be horribly offensive. Bait and switch is an advertising technique that sometimes is illegal, but in all cases, it is fundamentally dishonest. Typically, in that context, a low price is advertised in order to capture the other party. Here, we have a family that honestly, a hardworking family that honestly and in good faith entered into a long-term lease contract to provide rents for the family over the long term. The person who made the lease, sadly and unfortunately, has now died. He's survived by his widow, children, and grandchildren. He accomplished this in good faith for his family. He entered into the lease contract allowing use of the property for a public purpose, to provide public parking downtown in exchange for a promise and an agreed fair rent income for his family. Most importantly, the family has never breached the lease. They've done everything that's required of them under the lease. This action that you're contemplating to condemn the property despite a valid written contract is both morally and legally wrong. It defies reason to believe that the project that we just heard described in about 2 minutes or less is in truth a public project. It is believed that Capitalize Albany through the condemnor is doing the bidding of a private developer. It is believed that this is unlawful and at best not candid. And there is a solid basis for this conclusion. What are the facts? First, Capitalize Albany admits it's a mere flipper. It is not a developer, and this is not a matter of a mere incidental private benefit to a private developer. The public and the Chambers family are entitled to know with full transparency who is really involved and to what extent. The reason for this is because by definition, private party benefit is not public benefit. Capitalize Albany has no experience with a project of the one described in a 2-minute interval or less. It has no suitable staff with a track record for experience for anything like this. And we know for a fact that Liberty Square Development LLC, that limited liability company, is not real and it's not thriving. It's not a real development company. It's an empty shell with no assets. What are the facts? The state budget deficit is $13.3 billion and growing. The city budget deficit is $16 million and growing. Each year, the city begs the state for about $12.5 million or more. The grant that was vaguely alluded to as this will not cost anyone anything is for about $10,193,720, if I've got my figures right from the state. A bundle of that's been spent. And while admittedly it's a substantial sum of money, it tellingly is not enough for a real public project. And I submit the intelligent minds, members of the IDA, understand and know that from their real life business experience. Simple math shows that the project simply can't be completed by the condemnor, which has no experience in a project of this nature. Indeed, looking at the Capitalize Albany website of accomplishments, nothing inspires confidence for the future of this property in its hands, in contrast with this family's solvent business. There also appear to be multiple conflicts of interest and repugnant interlocking relationships between the various boards, entities, lawyers, and members involved, together with the private sector. It is believed that the claimed public purpose label is really a disguise for a planned flip of the property to a developer or developers with interlocking connections. This is not a dominant public purpose required under the law. It is axiomatic that the current use, public parking, is a public purpose. We ask that you also consider the subject meeting notice for the purported meeting today. The paperwork that the IDA sent to Mrs. Chambers states that she has to object to the notice given to her right now, here and today. I believe you all appreciate that that is a very difficult challenge that has been thrust at her. In any event, there are defects with the notices of the public hearing. Indeed, even the recitation that we've just heard missed several of the elements required under the statute. Prior to today, on December 3rd, 2020, the family asked for copies of the publication notices and the affidavits. They have not received them, despite their polite written request. Indeed, as I'm here with you today, they remain withheld from the family and from me. Incredibly, instead of simply providing them, the family has been referred to a lawyer in Buffalo or Rochester in their effort to obtain them. And the lawyer has stated in writing that the materials will not be disclosed and that the family will have to wait to hear from him again for perhaps another 30 days. And then he will determine whether or not they will receive simple copies of the materials that the law clearly requires for a hearing like this. Indeed, in the preamble remarks, those materials were referred to. I think we all have computers. As I look at everybody here, and an email is an easy manner to transmit documents that have been reasonably requested, particularly by the owner of the property in the matter today. The family believes that the deliberate withholding of this information is intended to prevent them and the public from knowing the true facts. This deliberate withholding is compounded by the fact that the notice from the IDA for this public hearing states that if the hearing is challenged, it can only be challenged on issues raised at the hearing. Can you imagine that, if that were happening to you? The family asks you to just consider, is it fair and reasonable to withhold from them the documents on which the challenge could be made until a month or more after the hearing? Is this good faith? Is this common sense? And I submit, who's making these decisions? They're arbitrary at best, certainly irrational. Is this how the IDA treats city taxpayers? I submit the IDA is better than this. It's better than the treatment, this shabby treatment that's been afforded Mrs. Chambers. The family received notice of this hearing today on November 30th. No one called them in advance, despite knowing them. No one contacted their lawyer, despite knowing him. The notice came by certified letter. The notice is defective for many reasons. One reason is that the law requires that the notice is required to be made at least 10, but no more than 30 days prior to the hearing. In either event, the notice is defective as November 30 was less than 10 days from today. What is more troubling is that it appears that the condemnor has made a conscious decision to deliberately withhold notice until the very last possible second. In any event, putting obvious bad motives aside, the notice simply is too late under state law. The law requires that the condemnor give notice to the public. It did not do so. Despite the family's request, the lawyer in Buffalo or Rochester will not confirm publication of the public notice required to have been in a newspaper. The notice does not state what the project consists of. There's no information in the notice that's necessary and required to intelligently conduct a meaningful public hearing today. Indeed, the notice is less than 2 pages of text, the bulk of which has absolutely nothing to do with a project at all. In fact, the only mention of a project in the less than 2 pages is this, quote, an economic redevelopment plan involving a mixed-use development concept called for by the Capital Region Economic Development Council's Capital 2020 Regional Development Strategy. That's it. The project, which I say advisedly in quotes, the project is by definition a mere, quote, concept, end quote. A concept, by definition, is an abstract idea. The claimed project is merely a figment of imagination or a dream. It is not a project as required to be described under the eminent domain procedure law. This is not a project. There is nothing that states how the property is intended to be used. The notice does not have any information on which to assess whether or not too much or too little property is intended to be taken. And the notice also fails to state any alternate locations for the potential project. The meeting and public hearing are unlawful for violation of state statutes, and also because the authority is not lawfully constituted. The members are not legally qualified to serve, and thus this meeting and the public hearing is a legal nullity. The notice was not published in at least 5 successive issues of an official newspaper. In this regard, it bears mention that the family has largely remained quiet and polite, as Capitalize Albany has widely circulated innumerable press releases. In fact, in some instances, members of the family were directly contacted by the leadership of Capitalize Albany just before a press release was released. And efforts were made to pressure the family members to make certain public statements in favor of an as yet un and ill-defined, in quotes, project, purported project. Respectfully, The point is this: for this hearing, there was no publicity of any kind or any nature. Nothing in the Business Weekly and nothing in the Daily today. None of the required legal publication was done, and certainly nothing consistent with Capitalize Albany's past practices of employing puffing press releases. The absence of required publicity is not mere inadvertence, but rather calculated and intended in concert with the other activity of withholding the documents from the family to deprive the family and the public of any meaningful opportunity to participate in a process required by law. I was struck by the fact, and I hope you were too, no one else registered to speak. The saddest part of this defect is that serious, credible economic developers and public project developers know better. They know that better public projects result when the public is invited and, in fact, encouraged to participate. In this case, shamefully, the public has been marginalized and its rights violated. The notice. The notice also fails to state that there's been any required compliance with the laws concerning environmental review. In fact, the notice doesn't even contemplate it. Fails to mention environmental review at all. It's believed that there has been a wholesale failure to comply with the rules and the regulations pertaining to environmental review with the Environmental Conservation Law and with seeker. Importantly, without a real and defined project, in other words, a project which is a figment of one's imagination or a concept, would be rejected at any responsible municipal review board in the state of New York for failure to have a complete application and failure to have sufficient specificity. Without a complete application and without sufficient specificity, this figment of one's imagination, this concept cannot be intelligently reviewed and assessed as it relates to the environmental and historical impacts on this site. I believe you know that some of the properties that we're discussing today have been identified as having specific historical significance as it relates to the city of Albany. It appears that the pertinent legal requirements have been entirely neglected. They've been trampled over, and in the language of seeker, with no hard look. In fact, no look. In simple terms, this all amounts, as you reflect on this today, and I appreciate if you would, what does this all amount to? In simple terms, what this amounts to is an invasion of private property rights. This is a sad case. It's terribly sad. The family has been forced by the condemnor to have to deal with at least 5 to perhaps 10 different lawyers acting for the condemnor over the recent past concerning their property. This is in addition to efforts to meet and discuss the project and, significantly under the law, a fair and a reasonable price. What is important about this is the fact that the IDA has never made a written offer to acquire the property. If the IDA wanted to, it could have negotiated in good faith and followed the law, just like Mr. Chambers did in 1988 when he negotiated the lease and made a fair deal. The bulk of the notice for today has a boilerplate regurgitation of New York executive orders purporting to justify why there's no real meeting or real public hearing today. The law does not allow a virtual or remote condemnation and destruction of constitutional rights. None of Governor Cuomo's executive orders have modified any aspects of the EDPL or case law. The executive orders themselves have been widely considered unconstitutional. The United States Supreme Court recently found a New York executive order to be unconstitutional in Roman Catholic Diocese of Brooklyn versus Cuomo, which was decided on November 25th, 2020. Describing the action of the executive as, quote, very severe restrictions, end quote, and therefore unconstitutional. Here, the condemnor has violated the plain language of the statutes designed to protect the public and this family from government taking of their property and their business being taken from them. Pandemic or not, property owners and citizens have fundamental constitutional rights. Here, the family's business and their rights are violated by the litany of unlawful and deliberate violations of law. No one may be deprived of their property without due process of law. Sadly today, this taking is being aggressively pressed against Mrs. Chambers, an 83-year-old grandmother in the heart of the pandemic. Albany County's daily numbers are more than 205 new cases per day. And we've lost count, but the total of cases is in excess of 10,000 cases. Incredibly, the notice of this hearing explicitly states that she is not allowed by the condemnor to be present. Mrs. Chambers must Zoom or call. That is not what the law says. No law stands for the disturbing idea being advanced here in this proceeding that government can take your property and your business from you over Zoom. In conclusion, the family asks members of the IDA respectfully that you please think better of this ill-conceived, unlawful, and misguided attempt to condemn Mrs. Chambers' property and her business. Mrs. Chambers and her family are asking you, members of the IDA, to be strong. What they're asking of you is do not simply agree to take her property from her because someone whispered outside of the public earshot. Just do it. Do not close your eyes, your ears, and your minds and hope without any basis that somehow it will all work out because someone with no track record advocates this real long shot and a flip to a private developer. That's too great a risk. It's also unlawful. Mrs. Chambers and her family are respectfully asking that you prevent the closing of the IDA's own thoughtful mind. And respectfully, we ask that you prevent a rubber stamp without consideration of the true facts. This proceeding should be stopped. This is fair and reasonable and lawful. On behalf of Mrs. Chambers, thank you very much for your time and your attention and your service.
Thank you, Mr. Kadiri, for your comments. The next speaker that has indicated they would like to be called on is Adam Driscoll. Adam, if you could unmute yourself, and you have the floor.
Oh, I apologize. I had signed that up for the home leasing application.
Okay. Is there anybody else on this matter that would like to be heard? Again, if you're on the phone, *9 will raise your hand. If you're on the Zoom software, you can select the raise hand button. May, at this time, I'd ask you to just unmute everybody that's on the phone, in case
Will
they
do.
can't
Thank you.
get that done, and then I'll make one last call.
At this time, everyone who is on the phone has asked to be unmuted.
Is there anyone else who would like to provide any comments on this matter? Again, if you're on the phone, *9. If you're on the Zoom platform, click your raise hand button.
Hi, I don't have a comment, but can I ask for the record the correct spelling of the gentleman who was speaking at the beginning?
The spelling?
Yes, please.
That was me, I believe, Chuck Malcolm. Last name is spelled Malcomb.
No, I'm sorry, the attorney who was speaking?
That I am the attorney that was, you mean providing the presentation on the public project, or are you talking about?
No.
You're talking about
Oh, yeah.
William Kinnery.
Yes, can I have the spelling, please?
It's Keniry.
Thank you.
Sure.
Thanks, I wasn't quite getting that.
No problem.
Okay, there being no further comments, the public hearing will be closed at 12:50 p.m. Further statements will be.
Chuck, if I may interject,
Sure.
we do have somebody raising their hand.
Oh, we do.
Caller ending in 8285.
Okay. Caller 8285. Go ahead. Okay.
That was it. That was in error. No comments. Thank you.
Okay. That being an error and no further comments, the public hearing will be closed at 12:51 p.m. Further written statements can be submitted to info@albanyida.com until 5 p.m. on Tuesday, December 15th, and they will be part of the public hearing record. Chair
Thank
Metzger,
you.
back over to you.
Thank you. With that, this public hearing is now completed. Thank you.
Just let me know when I can start. Am I ready to go or? I think you're muted, Sarah.
And May, we're ready to go.
Experiencing technical difficulties.
So hold off.
Yes, I appreciate it. Thank you.
Yeah, just give us a minute to transition, Darius.
Is my audio on now? Still no?
Yes.
Yes, great.
May, I think we're set, right? We're on YouTube and we're recording.
May's computer froze, Joe. That's why we're still having problem getting off that YouTube stream.
Okay. Thank you, Mark.
So, Joe Scott, she's gonna have to actually drop out of the Zoom. Her Zoom program is actually frozen on her computer. Just in case it drops everybody from the meeting, I just wanted to make you aware of that before she goes ahead and does that.
Okay, I think it'll stay on because I think I'm the co-host. So I think we'll hold on. Let's give it a try.
Joe, this is Debbie McByrne. Do you hear me?
Yes.
Do you still need me, the court reporter?
No.
For this next done, right? Okay.
Thank you.
Just wanted to double check. Have a good one. Thanks.
Thank you. So Mark, you dropped?